Got it up and running. Are we all good?
All good to go.
Fantastic. Our cause number 19-033971 CV Victoria Denning versus Zeta Lambda New Fraternity. Council, please make your appearances for the record.
Melanie Velasquez and Sarah Overcash for the plaintiff Victoria Denning on behalf of Kenny Denning.
Velasquez and Overcash.
Yes, Your Honor.
Good afternoon, Your Honor. My name is Maddie Suttles, and I'm here alongside my co-counsel, Bashara Randolph. We are here for the defendant, Zeta Lambda Nu Fraternity.
Okay, are there any preliminary matters we need to take up? Let's start with the plaintiff. Ms. Velasquez, Ms. Overcash, do we have any housekeeping?
Yes, Your Honor. May we question from the seated position?
It's up to you. Do whatever you want.
May we move about the courtroom briefly during opening and closing? Yes. May we assume that all exhibits have been pre-marked and pre-authenticated?
Yes.
And may we assume the witnesses have been pre-sworn?
Yes.
And lastly, may the witnesses leave the room once they're testifying if they wish?
Yes.
Thank you, Your Honor. No further housekeeping matters.
Defense, is there anything further?
Nothing further, Your Honor.
Okay, do we have any motions to eliminate?
Yes, Your Honor. First, we with William Counsel, and we wanted to pre-admit exhibits 4, 5, and 6.
Correct.
Yes, Your Honor. Yes, Your Honor.
All right, 4, 5, so we admit it. No.
And we would like to publish these exhibits to jury.
Once they've been pre-admitted, you have either side has ability to use it freely.
Further motion. As you may know, this case is about the wrongful death of Kay Denny, a 20-year-old college student who suffered fatal injuries and lost her life at a fraternity party hosted by Zeta Lambda Nu on May 25th, 2006. The plaintiff, by and through counsel, respectfully moves to court for an order excluding evidence from trial. First, we ask the court to exclude evidence of Chris Booth's shoplifting conviction on the grounds that it is prejudicial and improper character evidence.
Any objection?
Yes, Your Honor.
How long ago was the conviction?
It was about 2 years. 3 years ago.
Okay, response?
Yes, Your Honor. A shoplifting conviction goes to the truthfulness of this witness, and thus we think it is very relevant.
Yeah, it's a crime moral turpitude that's denied. What else?
We ask the court to exclude evidence of Ms. Denning's academic record and sorority suspension on the grounds that it is prejudicial.
Response?
Yes, Your Honor. We are also objecting to that. Ms. Denning not being allowed to attend the party is part of our case in chief, and her suspension from the sorority is relevant to that.
Okay, well, how? Make the connection for me.
Yes, Your Honor. In the invitation made to Ms. Denning, it was to all sisters in good standing, and Ms. Denning was not in good standing, and thus if this is admitted, we would not be able to establish that.
Ms. Velasquez, your response?
Response that Ms. Denning was invited to the party, but through someone directly related to fraternity, not through the invitation.
I am going to grant the motion eliminate, but you can just, all that means that you can't talk about it in your opening and just approach before you bring it up. And we will see if they've laid a proper foundation for it, and we can talk about whether or not it comes in later. All right, what else?
And we ask the court to exclude exhibit 14 on the grounds that it is prejudicial. It is a photo of Ms. Denning at an unknown party with no one here to testify as to who it was.
A response of 3.
Yes.
Motion.
Yes.
Yes, Your Honor. It also goes to show Kay Denning's character. It was taken at a party the weekend prior.
You want to get it in as character evidence?
I confer with counsel.
You absolutely may.
Your Honor, may I ask if this is going to be excluded from opening solely or throughout?
No, I mean, she wants to exclude, I mean, it's a motion and eliminate. If I exclude it, we're excluding it.
Your Honor, if they would like to also exclude exhibit 13, which is another photo of Ms. Denning, then that's all right.
Well, no, they've only asked about 14. Here's what we're gonna do. Motion and eliminate, we're talking about topics of evidence with regards to exhibits. If it's not pre-admitted, you want to get into it, you just lay a foundation, we'll take it up at the time. So technically, it's denied, but because it hasn't been pre-admitted, it can't be used in opening, and obviously you can't show it to a jury until it's been admitted. So 14 is denied. What else?
No further motion being matters.
Right, does defense have any motion limiting?
Yes, Your Honor. The defense moved to exclude any evidence in reference to prior incidents revolving around Zeta Lambda Nu, including the 1993 drowning incident, and this is referenced in Exhibit 10. These incidents are irrelevant to the case at hand.
Response?
Response, Your Honor, we want to show for knowledge that this party was recommended to another party. They got the idea for this current party from that past party with very similar incidents. Additionally, we do have Officer Bell who was present at both.
Tell me why it's not prejudicial. Like, what is the connection? So they got the idea from another party, okay, and
Probative value substantially outweighs the.
what is, that's what I'm asking you. What is the probative value?
Party can show for knowledge and proximate cause. The fraternity would know that this incident could happen again.
What's your response to notice?
Yes, Your Honor. Prior references to prior tragic incidents could unfairly bias the jury against the defendant by suggesting a pattern of negligence that is not substantiated by the evidence in this case.
Okay, but with regards specifically to notice, right, they're trying to say that y'all fraternity should have known that something like this happened. Sorry, I'm trying to find my glasses and I cannot find them. Trying to say that fraternity should have known, so why should this not come in to show that the fraternity should have known?
Yes, Your Honor. No one here testifying today was a part of that party in 1993.
Response.
You know, well, I mean, regardless of people testifying or not, I know you've got a limited universe here, but are you saying that nobody at Zeta Lambda Nu is gonna be able to say that was aware of the existence or what happened in this party that happened in the 90s?
Well, Your Honor, I'm just saying that this was over 25 years ago. I think that it has lost its relevance to the people planning the party today.
Wouldn't that be a fact issue? I mean, what I'm gonna do, I'm gonna grant it for now, lay a foundation, disaster approach, so make sure you lay a proper foundation to show that it actually does go to notice. Because that's the only way it's gonna come in, is to notice, but I wanna see the foundation being laid for it. What other miles do you have?
Yes, Your Honor. The defense now moves to exclude Exhibit 7 and Exhibit 8. These contain text messages between Kay Denning and Andrew Dornberg. And they also consist of text messages between Andrew Dornberg and a Chris Bloom. And these are on the basis of hearsay under Rule 802.
Well, then what, it's exhibits, so we're gonna take this the same way we take 14. I'm not gonna deny, I'm not gonna admit her. I'm gonna grant or deny it as a motion, well, actually, I'm gonna deny it as a motion limiting, because I don't think it's proper for MIL. But because it hasn't been pre-admitted, obviously, you can't show it without laying a foundation for it. And you choose to chalk about it in your opening, you do it at your own peril, because if it gets excluded, make a promise to the jury you can follow up on. So technically, I'm gonna deny that. What else?
Nothing further, Your Honor.
You ready to proceed with opening statements?
Yes, Your Honor.
Boss, what's your proceed?
This case about a wrongful death and a failure to have prevented it. Negligence has a price. And in this case, Ms. Denning paid the ultimate price with Zeta Lambda Nu. But she shouldn't have to pay both. Your Honor, members of the jury and opposing counsel, my name is Melanie Velasquez, and I, along with my co-counsel Sarah Overcash, represent the plaintiff, Ms. Victoria Denning. Ms. Denning brought this case again as a grieving mother and as administrator of her deceased daughter's estate against Zeta Lambda Nu. Throughout the course of today's trial, we will show you why Zeta Lambda Nu needs to be held accountable for their actions. On May 25th, 2019, Ms. Denning, 20 years old, was invited to a Zeta Lambda Nu fraternity by a fraternity member, Mr. Dornberg. Mr. Dornberg was a treasurer of the fraternity. Evidence will show that Mr. Dornberg denied Ms. Denny multiple times through the afternoon. Ms. Denny complied and did go to the party to meet Dornberg. Despite seeing her intoxicated state and not inquiring into her age, Ms. Dornberg allowed her onto the party's premises. Then, in the early hours of May 26, 2019, Ms. Denny, still impaired and vulnerable, climbed onto a rickety lifeguard chair that was placed next to a pool for just 1 minute. Ms. Denning unfortunately fell into the pool and suffered massive brain damage. She was on life support for 6 days. and then was able to- You will hear from 4 witnesses who saw and responded to what happened on the night of the tragedy. First, we will call to the stand Chris Bloom, Ms. Denning's close friend. She will tell you about the events leading up to the incident and how Mr. Dornberg's actions influenced Ms. Denning, who was in a vulnerable state. Next, you will hear from Officer Alex Bell, who investigated the incident and interviewed people who witnessed the tragedy. He will share the incriminating evidence and testimony that he collected. The defense will call for Courtney Perez. Ms. Perez helped plan the Zeta party. She was in charge of standing at the door and enforcing a 21+ policy. But although that rule was stated at the we weren't enforcing it. Finally, the defense will call to the stand Andrew Dornberg himself. You will hear in his own words how his actions contributed to his tragic and preventable loss. When you put all of this testimony together, the picture will be clear. The fraternity, through its representative, Andrew Dornberg, negligence. Now, what is negligence? Negligence happens when someone has a responsibility to act carefully. When they fail to do so, they cause harm as a result. The defendant admits that it had a responsibility to Ms. Denning to keep Ms. Denning safe as a guest and invitee. The defendant failed in that responsibility in 3 key ways. First, by admitting Ms. Denning to her party at the fraternity house when it knew or should have known that she was not of legal drinking age. Second, by admitting Ms. Denning to the party at the fraternity house when it knew or should have known that she was intoxicated. And lastly, through Mr. Dornberg, directing Ms. Denning to dive off the lifeguard chair into the shallow pool when he knew or should have known that she was intoxicated. Because of this failure, Ms. Denning suffered severe brain damage, which ultimately led to her death. The evidence and testimonies will show you that if the defendant had acted responsibly, Ms. Denning would still be alive today. Under Lone Star law, we, the plaintiff, have the responsibility to prove our case. The law calls this the burden of proof, and we must meet it by a standard known as preponderance of the evidence. What does this mean? You can imagine a scale. On one side represents the plaintiff's case, the other side represents the defendant's case. If even a feather's weight tips the scale in our favor, the law says you must listen. But today, you won't see just a feather. You will see clear, undeniable evidence that proves the defendant's negligence. We will meet and exceed that burden of proof. After you've heard all the evidence, we will ask you that you return a verdict to the plaintiff, if victorious, to hold Zeta Land and New Fraternity accountable for the decisions they made them. Because negligence has a price, and it should not be paid by the victim of Zeta Land. Thank you. That's all.
Mayor President?
Yeah.
May it please the court. Your Honor, opposing counsel, members of the jury. The weight of choices. Every day we make choices. Some are small, the ones we don't think much about, the ones that affect our lives in small, imperceptible ways. And then there are those that carry weight, the ones that linger and haunt us, the ones we wish we could take back. The night of March 25th, 2019 was meant to be unforgettable. Zeta Lambda Nu was hosting their annual pool party, and a scene was straight out of a movie. Sand scattered across the lawn, tiki lights shine from overhead, and in the center of it all was a pool. Overhead was a lifeguard chair. Now, for the party guests there that night, this party was a perfect escape from the stress of college exams and deadlines. But Zeta Lambda Nu had clear rules for this party. The main one being that this party was meant for adults. To enforce this rule, they put up a sign, 5 to 6 feet long. Must be 21 to enter. This was at the entrance. Also at the entrance was a student stationed there to check IDs, denying those that could not prove that they were an adult. And while Zeta Lambda Nu upheld its responsibilities, a 20-year-old girl, Kay Denning, made a series of choices that carried weight. See, prior to arriving at Zeta Lambda Nu that night, Miss Denning had been drinking. Well, members of the jury, not just one drink, but enough drinks to impair her judgment. But she arrived at the door, and once at the door, she was denied entry because she could not provide an ID. But instead of accepting that decision, Kay insisted that she would find a way in, and tragically, she did. Members of the jury, even after the party was over and guests were told to leave, Kay stayed. And in those final moments, she made the most devastating choice. She chose to climb up the lifeguard chair and dive to her death. Members of the jury, it was horrific. Good afternoon, Your Honor. My name is Maddie Sittles, and I'm here alongside my co-counsel. We represent the defendant, Zeta Lambda Nu, in today's case. Now, we are not here to argue that Zeta Lambda Nu was blameless, but today we will bring forth evidence that will show that Kay Denning bears the majority of the responsibility that directly caused her death. Now, to prove this, we will be calling 2 witnesses to the stand today. First, you will hear from Ms. Courtney Perez, and Ms. Perez was the student stationed at the door that night checking IDs. She will testify that she saw Kay Denning come to the door, that she denied her entry. But she will also testify, members of the jury, that hours later, when she saw Kay Denning again and asked her to leave, she did not listen. Then we will call Andrew Dornberg to the stand, who at that time was the treasurer of Zeta Lambda Nu. He will testify that he also asked Miss Denning to leave. And at that point in the party, it was after the party had already been over and innocent interest. Members of the jury, the evidence will be clear that Kay Denning was intoxicated before arriving to Zeta Lambda Nu, that she was not welcomed into this party, and that she climbed the lifeguard chair and dove to her death. And unfortunately, those were her choices and her choices alone. And that is why at the end of today's trial, my co-counsel, Bashar Randolph, will come up here and ask that you return a verdict that reflects truth. But yes, while Zeta Lambda Nu does bear some responsibility, Kay Denning's own choices directly led to her death. Because choices have weight. And some choices we cannot take back, no matter how hard we try.
Then call first witness.
And of cause Chris Bloom to stand.
It's the witness stand. I'm just saying, since we're recording, you may want to put the witness stand literally where she is right now. That way people can actually see it, because. Yes. That way they're gonna be able to see it. Yep, see.
Could you please introduce yourself to the court?
Yes, my name is Chris Bloom.
And did you know Kay Denning? How did you know Kay Denning?
She's my childhood best friend.
And why are you here today?
Because unfortunately, we did everything together. She's no longer here.
Let's talk about the event that brought us here today. Where did you begin that day?
Yeah, I came to visit Kay, at her college in Armadillo, and I got there kind of late, around 4 p.m. and we decided we were going to go to little Mexican restaurants and then try to explore into it.
And where did you end up hanging out?
We ended up walking by Zeta and then
And did you end up staying there?
no, we didn't. We were walking by and we got sent.
What did you see as you were walking?
It was quite a busy scene. There was a lot of fraternity brothers running around. I saw what looked like a party being set up, especially like there was a tiki bar, there was sand, a lot of sand, and there in the middle of the day, with some guys floating on racks in there, and then a big chair with someone on top.
And who was that on top of the tree?
I ended up finding later that was Andrew Longer. And he was yelling to the telephone that he was
Permission to approach the witness that has been previously marked as Exhibit 5.
Yes.
With the record of the claim showing this intent for verification purposes.
It has been pre-admitted, right?
Yes, right.
Being freely used. They could be admitted even freely used.
And we have published this to the jury. So what exactly is this chair in relation to Miss Denning's death?
This is the chair that
And could you see all of that chair when you went to Zeta?
no, I thought it was quite odd. The bottom wrong, maybe the bottom two, but I didn't really see those. So I remember that's all.
And why did you notice that?
Oh, it was just because a large chair in a pool I've never seen before. In the pools before, and then see the lifeguard chairs, they made out of metal and they're built into the side of the participant.
Okay, and did Andrew Dornberg stay in the chair?
No, he called out to us on the microphone, and he told himself. Then I remember he started to walk us and he climbed down. Actually, he fell down the chair and started walking to us.
Okay. And why do you think Mr. Dornberg stopped y'all going by?
What kind of speculation?
Response.
Because she's providing her own testimony of why she thinks Mr. Dornberg might have, the jury is free to reason if it's.
Why is it not speculation? I mean, literally, you're asking this witness to guess what somebody else thought. Or guess what
I'm
somebody
gonna
else
face
did.
Your Honor.
All right, the objection sustained. Your first question. Please vote.
What did Mr. Dornberg say as y'all walked on?
Objection. I can cause the hearsay.
Response, Your Honor. This is an admission by a party opponent under 801D2.
May I respond? So I theory of the case is showing that Andrew Dornberg during the day in question was not acting as an agent of the fraternity, but on his own volition in a personal capacity. So this is actually up for debate, question of fact for the jury to decide.
Response, Your Honor.
Ma'am?
If it is truly a question of if it was in a representative capacity, then it should be up to the jury to decide if that is something that they're weighing. And it does appear to be within the qualifications of 801D2A was made in a representative capacity, as inviting members to the Zeta party was something that Zeta members were supposed to do. They sent out invitations.
May I respond?
Yep.
They haven't made any foundation that that Andrew was actually acting in a representative capacity. So
Are you trying to say that Mr. Dornberg did not invite Denning to the party?
well, I guess the question calls for hearsay. I'm not part of his statements to that they're about to testify to.
Lay a foundation as to who Mr. Dornberg is in relation to Zeta Menu. Objection sustained at this time. It doesn't mean they've been excluded. I just need more foundation.
Yes, sir. Was Mr. Dornberg a member of Safe Community? Yes. And what did Mr. Dornberg appear to be doing as you came upon Zeta?
Instructing, the other.
And what was he instructing the fraternity brothers?
We had to do it.
And Mr. Dornberg, what did he say to Miss Denning as y'all were walking by?
And you, sure.
Did he invite her to the party?
Yes.
So did y'all stay there? Where did you go next?
Then exchanged phone numbers, with Mr. Goldenberg, walked back to his sorority.
And what was happening at her sorority house?
It was a typical kind of, phone numbers, go to them, and go out.
And where are they planning on going?
I believe where them do it.
Okay, well, let's talk about when you arrived to the dinner party with those sisters. What happened when you got there?
We were in a group of 6 or 7 people, and we approached them to the house.
And were you let into the house?
No.
Why were you not let into the house?
We did not have our IDs.
Okay. Was Kay with Miss Denning fine with not being let into the house?
And after Mr. Perez, mentioning that Andrew, invited her, and she was looking to see Andrew, and she went through the conversation.
Did y'all stay there?
We did not.
Where did you go for it?
We went to 3 different places, but we ended up at this apartment party with me.
Did you stay there a while?
We did 2 to 3 hours or so.
Did you drink at the party?
Yeah,
Did Miss Denning drink at the party?
she did.
And do you have any sort of idea how much she drank at the party?
I believe that previously mentioned before drinks that I could see. I didn't thoroughly track her throughout the party or her drinks, but I can tell you that she seemed visibly wasted.
And did she want to stay at the party with you?
No, she didn't. She wanted to see Andrew
So did y'all go back to Zeta?
separately.
Permission to approach the witness with what has been previously marked as Exhibit 8. Did you send text messages to Mr. Dornberg?
Yes,
And without going into the specific contents, do you recognize Exhibit 8?
I do.
And without going into specifics, what is Exhibit 8?
Text messages.
Does Exhibit 8 fairly and accurately depict the text messages between you on the day you sent them?
It does.
At this time, we'd like to offer into evidence Exhibit 8.
Throw an opening objection.
Objection to hearsay and also to more prejudice than prejudice.
Sponsor Hunter.
Start with hearsay.
This is an exception to hearsay if regarding Ms. Bloom's text messages. She's talking about being worried about Kay, which is an exception under 803.3, an existing mental, emotional, or physical condition. And Mr. Dornberg's text message is an admission by a party opponent.
Thornburg is not a party, is that correct?
He is a representative of Zeta. He's the president of Zeta, and he was the treasurer of Zeta at the time of the accident.
Been officially designated as a representative, is it?
They didn't talk about him being the treasurer. She doesn't know that, so I'm gonna say lack of foundation.
I didn't lay that foundation, it's not in evidence yet. But let's just say that she does lay that foundation, what is your response?
I'm still gonna argue that he's a representative.
You gonna argue or you just doing it? Do it.
Andrew was not representative of the fraternity. It's our argument, so I'll say that. And then as far as more prejudice than probative, the last text sent by Andrew is gonna do more harm. In this case, it's just gonna see the jury unnecessarily. Again, a text say admitting fault by someone who hasn't been established as a party opponent, hasn't been established that the treasurer, by this witness. And that witness is actually here today. So if they would like to try and admit this text under Andrew Dornberg, I think that's a more appropriate time to try. But letting this witness talk about it is more prejudiced.
I'm gonna let let them try the case any way they want to. What is your response to the, I mean, I tend to agree on the hearsay, but so that we don't have to keep coming back in front of me, what is your response to the 403?
I think the probative value is substantially outweighed by the chance of prejudicial value. I mean, Mr. Dornberg is saying he's taking accountability for the actions, and as far as it not mattering because he was not in a representative capacity, it is foundation that he was instructing the pledges on how to build the party, and he was responsible for the setup and setting it up. And this witness can't testify as to whether she knew he was the treasurer or the president because she's from a different college, but she does have experience in seeing him set up the party.
Right, but that doesn't mean that for it to be an admission by a party opponent, he's gotta be able to speak in some representative capacity for the organization. We haven't laid that foundation yet. If you can lay that foundation, I'll allow you to talk about it, but as of right now, the objection is sustained.
Your Honor, as counsel has stated, would it be more appropriate to use this in Mr. Dornberg's?
This time with this witness, based on the evidence that's put in front of me, that objection is sustained. You get more evidence in, you might be able to change my mind, but I'm just telling you based on what you've got in the record right now.
Yes, Your Honor. Let's talk about the accident. When you arrived at Zeta, what did you see?
So, Mr. Dunbar,
Objection to hearsay.
This is going to be the same objection of admission by a party opponent in a representative capacity. This is during the party. He's organized the party.
Yeah, I still don't think you've laid a foundation that he's a representative of Zeta. Is there some other exception by which you could think of it? Might be able to come.
Think of excited utterance as well. It's a confession.
I don't know what she's gonna say yet. What is she gonna say that she said?
Hey, baby, I'm here to
Do
talk.
you want us to approach before she says that out loud?
Yes, maybe approach.
Nay. You don't have to physically do it, but like, let's get this outside the presence of the jury. All right. So now that we're strictly outside the presence of the jury, Ms. Overcash, what is Ms. Bloom going to say if allowed to testify as to what Mr. Hornberg has said?
He says, hey, baby, I'm here to top you off. Don't you go diving without me. Don't you go diving without me? I would argue it's a command. It is a command. And a command is not asserting truth. So definitionally, it's not an out of court statement used for the truth of the matter asserted.
It's not an excited utterance. And it is being offered for the truth of the matter asserted that, sure part of plaintiff's case in chief is that Andrew demanded or declared or instructed Kay to dive off the
Lifeguard stand?
yes, so it's being offered for the truth of the matter asserted, thus it is hearsay.
So I'm gonna come in under admission by component. I'm gonna allow it to come in under, we can talk about this later. I'm gonna allow it to come in. I think you need to establish a little bit more foundation to get it under excited utterance, but that's probably how it's gonna come in. So do that. And then if you're able to lay that foundation, then we'll let it. So again, okay, for now,
Was Mr. Dornberg walking out of the house?
No,
Did Mr. Dornberg, without going into the specifics of what he said, did he say anything calmly?
oh,
Objection, and I ask that this be stricken if the objection is sustained to hearsay.
Yes, Your Honor.
well, she hasn't said anything that he said. It was the manner in which he said it, so I'm gonna allow the objections overruled.
again, he was yelling.
And what was happening when he was yelling?
It's hard to a little painful, but I remember looking over and seeing her very basic, struggling to climb up that tower. At this time, I'm just focused on her. I'm yelling, I hear another person yelling as well. And that's the moment that I saw my best friend fall.
And what was Mr. Dornberg saying as he was running the K?
Objection to hearsay, if just calls for it.
Response, Your Honor?
Yeah.
I've laid foundation that this is an excited utterance because he was yelling, he was running to her as she's climbing the
May I
stairs.
respond?
Yeah, you may.
They haven't laid foundation that it's an excited utterance. The excited utterance is from the declarant. They haven't established that the declarant saw Kay fall. They haven't, and they can't establish that because that's pure speculation on the part. But if they haven't established that Andrew, before he was yelling, saw Kay fall, it's not.
I don't think you need to see the fall for it to be an excited utterance. I believe the foundation's been laid, court's gonna allow the objections overruled.
And what did Mr. Dornberg say?
Hey baby, let me top you off. Don't feel diving without me.
And what happened when Miss Denning got to the top?
She struggled to get there, but I just remember the moment I saw her slip and it was up in slow motion and she did that water.
Thank you. No further questions. I pass the witness.
Yes, Your Honor.
Have your own, Mr. Randall.
Your Honor, may I ask if this is the law?
It is wherever you wanna put yourself, sir.
Thank you, Your Honor.
It's your dog and pony show. I'm just here to watch it.
Hi, Ms. Bloomfield. You wanted to go to University of Lone Star, is that correct?
I did apply there,
But you didn't get in
did not.
and your application was denied.
Objection, no.
It's going towards bias.
You know, a little legally on bias, there's legal and stuff.
Your application got denied
Yes.
because of shoplifting conviction.
That was my initial thought, but I can't say why in my mind.
But right now, you believe it got denied because of shoplifting.
I have previously stated that I believe my shot for conviction as per the law.
And you got probation as a result of this conviction.
I did, there was no felony, there was no misdemeanor, just no probation.
And you were convicted for stealing jewelry.
I was convicted for that. Didn't steal it.
So your statement today is that you didn't steal it, although you were convicted of stealing.
Yes, I do believe I previously said as well. I didn't take it.
So when you were with Kay on May 25th, there was an invitation in Kay's room,
Yes,
and Kay seemed nervous about it. Is that correct?
You seem unsure about the invitation, but this is after we.
Right, but she was nervous about the invitation in her room, yes or no?
Objections to cluster speculation.
That objection is, well, the way it's worded. I mean, I think we've have enough foundation there that she knows her, so I'm gonna give you a little bit of leeway on this objection.
Yeah, she was unsure about the invitation.
And do you remember what the invitation said?
Yes, it was an invitation to all sorority members of the family.
Objection, hearsay.
Response.
Your Honor, this is an invitation.
You may.
So as a reaction to the invitation, Kay was a little worried about something that was on the invitation.
She was worried. I believe she was worried just because she didn't know.
That's why she was worried?
She was worried because the invitation was.
Yeah, she was actually unenrolled in all her classes, is that correct?
She is, life happened.
And the invitation gave the perception to you that that might not apply to her,
Yes,
that she may not have been invited according to the invitation
according to the invitation.
because she was suspended from her sorority.
Yes,
Therefore, she wasn't in good standing.
I can't make that assumption. I don't know the sorority rules, but I do know that she was allowed to stay because she was being paid up.
And you do know that she was suspended from her sorority.
I do.
So this party, it was also for people who were 21 and up, is that correct?
I don't know. I didn't do the invitation myself. I do know that one was the sorority members, so I can't say that anyone else.
Objection, Your Honor. This line of questioning is concerning the exhibit which has not been admitted, and he's turning around the exhibit, asking questions that call her to reference the exhibit, and so I ask that he admit it first.
Yep, the objection is sustained.
So about Kay's unenrollment, Kay was pretty worked up about that, right?
Understandably, anytime you have a major life change, like dropping out of college, I would also have, like, personally, some trepidation about it, but life goes on. It's not all about school.
And she didn't tell her mom any of this about her suspended from her sorority, about being unenrolled in classes.
Not yet. I mean, when it comes to moms, like, you kind of want to try to make sure that it's in the right way. Conversations is constructive.
That's true. So you believe that Kay's mom, if she knew about Kay's unenrollment, that it would make her freak out?
Objection, speculation.
Response.
The witness has established a close friendship with Kay.
We're talking about Kay's mom now.
Right, and she, I'm just asking what her perception is about Kay's mom, how she would react.
Not
to
laid a foundation that she's perceived Kay's mom, the objection is sustained.
You know Kay's mom?
I do.
And have you ever testified that you know how she would react to information about Kay's unenrollment?
No, I can say that I know what like, great thing about them. They got the moms. What do you think about them?
So what did Kay think her mom thought about her? What did you think about her unenrollment?
I believe I used the phrase.
So-
Objection, this is referencing hearsay.
Yep. Also still speculation.
Yeah, it shouldn't be like that.
No.
So Kay was worked up about this, and she told you that she wanted to have as much fun as possible.
Objection, hearsay.
Response.
Your Honor, this comes in as an exception to hearsay as the declarant is for today. Due to it.
Okay. What rule permits this to come in under the declarant being unavailable?
So if the declarant is unavailable, it has to meet one of the exceptions under 804B.
Yep, because just because they're not here is not enough to get you there, so.
Yeah. So this is a statement, it's the interest of this party.
Describe. How does the statement, A, what is the statement? B, tell me how it's against interest.
So it's against the interest of the plaintiff because the statement is that Kay wanted to go
Plaintiff is
have.
the mom.
Sorry?
Plaintiff is the mom.
Right, but the decedent is a,
Right, but you said the plaintiff, so make sure we keep our parties straight.
right,
When you're referring to Kay, Kay technically is not a plaintiff because she's deceased. It's her estate. But you're referring to Kay Denning, correct?
yes, right.
I'm assuming that you're gonna want us to approach before he says anything that Kay said, right?
Yes, Your Honor, maybe.
All right, yes, we make it strictly approach. Go ahead, Mr. Randolph.
So Kay is the decedent of the Kay's estate. Or Kay's the decedent.
Kay's the decedent, done.
Kay's the
All
decedent.
right,
The statement is that Kay wanted to have as much fun as possible, which goes towards,
explain to me how that statement is a statement against Kay's interest.
because this case is a battle of negligence, of Kay's negligence versus the attorney's negligence, and that statement gives way to Kay's state of mind going into the night. And
Is that the only statement that Kay just says, I wanna have as much fun as possible?
before my mom finds out.
Did she say anything else?
That's right, give me a second.
Okay.
She told me she really cared. And she was going to get as much fun time as possible before her mom.
Yeah, that's the exact statement.
Response, Your Honor.
Yes.
For this exception to apply, it has to be so contrary to the declarant's proprietary or pecuniary interest or had so great a tendency to invalidate the declarant's claim against someone else. And a statement that she wanted to have fun does not meet that standard.
And without something else, just the fact that she wants to have fun doesn't necessarily go against her interest. The objection is sustained.
So you and Kay go out drinking frequently, don't you? Like you go and visit Kay often,
Yes,
and you all went to a party just a few weeks ago.
I get this frequent holidays.
That's not my question. Did you go to a party with Kay a few weeks ago?
Yes.
Your Honor, I'm appointing opposing counsel with proposed exhibit 14.
I don't need your help. Thank you.
Yeah, first witness will propose exhibit 14.
Ma'am.
What is this a picture of? Is it a fair and accurate description or representation of that picture?
No.
That you were there? That you were there? So, again, is this a fair and accurate picture of Kay?
It's K. I don't use.
Yes, it's Kay.
You mentioned.
No, of the picture. Is it a picture of Kay?
Yes.
Okay. And that picture hasn't been altered in any way? But you were at this party a few weeks ago. With this. And Kay was drinking at that party. So this is a picture of Kay drinking, which you were there at the party. So
I do see that, but again, I can't say it. She was all over in any way.
Your Honor, I would like to admit this exhibit as exhibit 14.
And picture 14.
Yes, Your Honor. The improper foundation, she did not take this picture. He says in her. I'll not go into that, but also, in addition to lack of foundation, it's also prejudicial. We have no knowledge of the circumstances of this party. There's no detail about this party from other witnesses. And for all we know, this could have been adult there. Kate's mom could have been there and could have handed her.
Why do the circumstances of it matter if it's a fair and accurate copy of the picture?
Oh, it's not a fair and accurate copy. I'm saying.
No, it's different. She can't answer whether or not it's been altered or not. But, I mean, she's testified that that's Kay.
She's right.
There was not any testimony to prove that it hasn't been, that's not, she's identified it as a picture of Kay.
Yes, sir.
Why does all the circumstances of it matter?
As far as if it's the foundation, I don't think the circumstances matter, but as far as the foundation, I'd say she didn't take the picture.
Don't have to
She
take the
can't
picture.
say if it's been altered or
Doesn't
not.
matter. You don't have to know if it's altered or not. Pictures, you don't have to be the person to take it. You don't even have to have the person take it on the stand to lay the foundation for it. They just need to be able to say, that's who that person is, right? And that fairly and accurately represents that person. So that's why I never liked asking the question whether it's been altered or not, because with photographs, you don't need it. Right? So,
In that case, I withdraw my objection to lack of foundation
but you still wanna maintain your objection to
to that its prejudicial value outweighs its probative value.
response to that, 4-3.
I want to withdraw my objections. I want to ask one more question.
You answer the question first and see if I overrule the objection or not, and if I, because you might be able to get it in. What's your response to the prejudicial, to the 403?
So this is Katie's friend, best friend Chris. They've been out together, to each other for testified to. They've been to parties together. It's been testified to, and so this picture is being used to establish that Katie has been doing a certain thing for a while that person knows about, and that on the event night in question, she was acting in conformity with it.
Okay, so you're using it for propensity. It's different. This is game. Answer your question to lay a foundation. Well, thank me, yes, maybe I'll still get it in. Go ahead, Mr. Randall.
I just want to be sure for the jury. Have you seen this picture before?
I have, was asked about it recently.
Okay, and this is a picture of a party that you and Kay were at together before,
Or what, sir?
before the night in question, a few weeks ago. You've all been to,
To be clear, they made it home this night.
that wasn't my question. And you've been to parties other than this with Kay as well, is that correct?
We've been out at parties. Made it home those nights too.
Okay. Your Honor, at this time, I think enough foundation has been added to the records to allow exhibit 14 into evidence.
Response, Your Honor.
Sarah Cash, do you have an objection? Is that a response? You have an objection.
Objection, Your Honor.
What's your objection?
That this is improper character evidence to show that she acted in that she had a propensity for partying.
Any response to that?
Can I confirm from counsel?
Absolutely.
So across examination for improper character evidence, we're allowed to improve by reputation. So examination, the character of the witness, the court may allow an inquiry to the relevant specific instances of the person's conduct. And this is a picture of Kay at a party. We're here to talk about a party on May 25th with David Besson, who's president as well.
And why does it matter?
They've been going to improve character, the reputation of Kay.
Okay, well, A, picture itself is not reputation evidence. It doesn't show reputation, but B, when it comes to propensity. Is there a question as to whether or not Kay had been drinking on the night that we're here to talk about?
No, that's been sticking to my vote.
Right, do you agree, Ms. Evercash?
Yes, Your Honor.
That is not the issue about whether or not she'd been drinking. So why does this picture prove anything that is in dispute? Because nobody's disputing that she was drinking the night of this party. So
Right,
what new does this tell us?
right, so it's not disputed that Kay was drinking, but the level of her intoxication is something that we're gonna be trying to establish as part of our case in chief. As far as this picture.
I heard from this witness that she was wasted that night, so I don't think the level of intoxication is a question either. Am I correct in that, Ms. Evercash?
Yes, Your Honor.
I mean, so I think everybody agrees that the plaintiff the decedent plaintiff, Miss Kate Enning, was really, really drunk on that night. So what is this photo?
I guess it doesn't, if they establish that she's really wasted.
Sustained.
Thank you.
So this witness said it, so objection is sustained.
So. You don't really like Andrew, do you?
I mean, I had none of it first time this day. I had not breaks, relations, sometimes I would have been in person with them, and my best friend ended up dead in, so.
So-
It's pretty, for me, that's logical that I wouldn't really like Andrew.
Is that a yes, you don't like him?
No, I mean, he's not my favorite person in the world.
So you don't like him, just be clear for the jury.
No, I don't really like him.
In fact, you were a little grossed out by him when he walked over and talked to you and Kate earlier in the evening.
Just the guys around, hanging out. It happened to stop by him and we had work after it's 4 days. And it's got to a point where I was just very uncomfortable with it. Like I was
Objection to mayor asking simple yes or no questions, and it seems like we're getting a cumulative response.
Yeah, I mean, your lawyer's gonna have an opportunity to ask you some follow-up questions to the extent you can answer the question you're being asked.
So you were a little grossed out by Andrew when he walked over. And you described his conversation with Kay as him hitting on Kay.
It was very flirtatious and
And Andrew was talking over you at times.
what?
This is typical frat boy behavior. So it really ticked you off that he was talking over you.
If I've already been in a conversation and it's over.
Yes, he really ticked you off.
It was like,
I'm using your words, yes or no, it ticked you off.
yeah, yeah, sure.
Thank you. And you described Andrew as a jerky man,
I did, I think,
and you hated that he called Kay baby, is that correct?
yeah, I don't like any guy that just has called someone baby.
That's a yes for the jury?
Would you like me to answer?
It's a yes or no question, so I would like you to answer.
I do believe I did say it.
So, it's been yes or no for the jury. You hated when he called you baby, yes or
Called baby?
no? Kay baby.
Yeah, yeah. I think so.
So after that conversation, you and Kay tried to get into this party,
Yeah, because
and Courtney didn't let you in?
No.
That's because you all didn't have IDs?
Mhm.
So Kay and Courtney started arguing.
Yeah.
They really wanted to get in that party.
She wanted to sing.
So she really wanted to get in the party.
Yeah, I think that's what she really wanted to do.
Andrew was in the party. She wanted to get in the party. Would you say Kay was determined to get in?
Yeah.
And later in the night, I mean, you all didn't get in, so later in the night, you all went to a different party. And Kay was drinking, but she had a lot to drink, right?
Yeah, bring up the question.
She had a lot to drink.
Yeah.
She was wasted.
Very wasted.
You were really worried about her.
Yeah.
She really wanted to go see Andrew.
Yeah.
You didn't want her to go.
No.
She went anyway.
Yes, I do so.
And before that, she also had 2 hits of something, right?
Yeah.
Cannabis?
I believe so.
A brownie?
There was, one of us at the party, I didn't take it, but I didn't see it.
So you assume she took the brownie?
When I was there.
And you know, during this party, they exchanged numbers, or they exchanged numbers prior to the party.
Yeah.
And during the party, Andrew was texting Kay.
Yeah, they heard some change.
And Kay really wanted to go see Andrew. And when she told you that, she could hardly talk straight.
She was going her way.
And you told her that going to Andrew's party was a bad idea.
Yes.
She eventually ditched you and went to the party anyway. And you assumed she went to the frat house and you followed her?
I had assumed that she'd gone, so I was searching for her.
You were searching for her because you were worried about her. She was really drunk.
No, that's fine.
So when you finally arrived at Zeta Lambda Nu, that's when you saw Kay climbing up the lifeguard chair.
Yes.
And then tragically you saw her fall.
I did see her phone.
Now at that moment, Andrew wasn't next to her, is that correct?
And then I was running.
So he wasn't next to her? Thank you. No further questions.
All right, sweetheart.
Please, Your Honor. Were Miss Denny and Andrew exchanging texts throughout the night? They were. Did you send text to Andrew? Did you anticipate that if you sent text to Andrew, he would read them?
Yeah, it seems logical because I know people respond to it.
No further questions at this.
Okay. I just want to speak excused. If she has better things to do on a Sunday, she may leave the courtroom.
Difficult Sunday, Your Honor.
I totally. That's me. I did not call you to court this day. I don't know why. Plan to call your next witness.
Your Honor, I call the stand. Yourself to the court.
Yes, my name is Alex Bell. I'm 52 years old and I'm sergeant at the University of Police Department.
Tell me where you walk for them.
Yes, I went to the University of Montreal. I received my degree in criminal justice. That's where I decided I wanted to stay there and go into school.
When you were a student at Lone Star, did you consider joining the fraternity?
Yes, I was a fraternity member while I was there.
Did you rush Zeta Lambda Nu? Were there any hard feelings for Zeta Lambda Nu?
No, I didn't get in. I joined another fraternity and we ended up having a party together. My wife and I, we had a good time, got along, so yeah, no hard feelings.
Well, let's talk about your experience being a police officer. How long have you been a police officer?
As long as I've been out of school, took me a while to do the math, but 2.5, 3 decades.
What training do you have as a police officer?
So I have my degree in criminal justice, and then following that, I went to the Lone Star Ranger School, where I received additional law enforcement training. For instance, accident investigation, interrogation, interview techniques, typical law enforcement training.
And what kind of incidents have you investigated on the University of Lone Star campus?
We see a good variety, minor shoplifting, vendor dinners, with it being a college campus, a lot of what I do with our alcohol related incidents such as DUIs or just parties that get a little bit out of hand.
Would you say you're very experienced in alcohol related incidents?
Yes, that's a lot of portion of what I do my day to day.
Officer Bell, have you investigated an accidental death?
Yes, I investigated one.
Sorry, your permission to approach the witness, will have the previously marked as exhibit 10.
Okay.
Officer Bell, do you recognize exhibit 10? Without going into confidence, what is it?
This is the report that I filed following the accidental death we talked about in the investigation.
Is exhibit 10 a true and correct copy?
Yes, it is.
Has been altered in any way?
No.
I would like to offer exhibit 10 as evidence, Your Honor.
Any objection to 10?
Yes, Your Honor, to hearsay.
Response?
Ms. Cohen, Your Honor, there's. Yeah, consult with my co-counsel. There's a record of a regularly conducted activity that's conducted in the course of the investigation 1993.
Response?
Yes, Your Honor, this is a document, they haven't certified that he should be able to write this document, so if there's no certification, then that exception is irrelevant.
Well, doesn't need a certification. But you haven't laid that foundation yet. I've heard no testimony from him about what you, the foundation that you need to get the exception you're going for. Sustain the objection at this time, see if you can lay that foundation, all right?
In the report that you're holding, did you have knowledge of the incident?
Yes, I was one of the responding officers to that incident.
Do you regularly conduct reports like this?
Yes, oftentimes we'll call this, we'll take secure evidence, conduct interviews, that sort of stuff, and it's typical that we file reports on our surgeons to document what we found or observed during investigations.
And Officer Bell, are you qualified to talk about the contents of this exhibit?
Yes, I was one of the responding officers. This is my personal report from that incident.
I would like to offer evidence exhibit 10, Your Honor.
I would like to object to relevance, Your Honor.
Now we're gonna do a different one. All right?
We are using this exhibit to establish Officer Bell's previous experience with the incidental death.
Okay. But why is it relevant to this one? Because as I see it, it is a 1993 report, which seems a little bit old.
Additionally, this is for knowledge. This was related to data lending.
Knowledge of what?
For knowledge, approximate cause that this could happen again.
When you say this, what are you referring?
Incidental death.
Be a little bit more specific than that?
Incident involving a tool made for
And how did that person die? In response to that.
Yes, Your Honor, nobody drowned in today's case. Somebody fell and died in this pool. Also, prior incidents do not make any fact or consequence in this case more or less probable. In today's case, the case centers around the events of May 25th, not a case over 25 years ago.
Your Honor, all of incidents that were involved the setup of data lending.
We're just gonna allow it to go to notice. Sections of rule.
Officer Bell, what was the incident?
Regarding a call I got to the table and new fraternity back in 1993. The party had a pool setup where someone had drowned.
The scene that data in this incident, what similar to the one in the previous incident?
Yes, it was markedly similar. That's one of the things I noted when I was called to the events in question today.
You also see those? Well, let's talk about the incident in question. Would you investigate Kay Denning's accident on the morning of May 26th, 2019?
Yes, I was one of the officers that responded at about 1:55 a.m. that morning of May 26th. For the 26th, I got a call, dispatch informing me that an incident at the fraternity, so I immediately headed that way.
What did you see when you arrived?
When I got there, I recognized it as a very similar setup to the incident accident that I referred to earlier, decades ago. There was a shallow pool area, tiki bar, a black car chair, a little beach area, alcohol bottles, cups strewn all over the place. I saw a group of people huddled on the beach area.
What were they huddled on?
When I approached, I realized they were huddled around the body. I didn't notice at the time. Later found out that it was Miss Kay Denning. She was unconscious, soaking wet, and dirty.
How did you respond to the incident?
Dispatch informed me that an ambulance was close by, so rather than render me no place, I began securing the area, canvassing it, and then when the ambulance showed up, I helped load and was standing into it.
And did you speak to anyone as you were conducting your investigation?
Yes, I canvassed the area, tried to see who had seen anything, and I concluded that there were really only 3 people who reported having seen anything. Chris Bloom, friend of the Stinnings, Andrew Dornberg, who was the fraternity treasurer, and Courtney Perez, who was the party organizer.
When you spoke with Ms. Chris Blue, what was her demeanor like?
She was very upset.
Objection, speculation, Your Honor.
Response, Your Honor? You could tell what Ms. Blue's demeanor was like, with her experiences, with the situations.
May I respond, Your Honor? Yep. You just said she looked upset. I don't think a cop has experience in determining whether someone looks upset.
Yeah, the objection sustained, you can talk about what you actually saw her do. But, yeah, that's why I think it's speculation.
When you spoke to Ms. Blue, what was his?
Well, I quickly realized he was drunk. He exhibited all
Objection, Your Honor,
physical symptoms.
speculation.
Response, Your Honor?
Yeah.
He's talking about Mr. Dornberg's symptoms of being frustrated.
May I respond?
I didn't hear any symptoms, I just heard the conclusion, so. Objection also sustained.
Spoke with Mr. Dornberg, what were his symptoms?
Well, he had glazed eyes, he had slurred speech, trouble maintaining balance, things that, during my investigation, my training, recognizing alcohol related incidents, these were all the signs that typical of someone who had been drinking.
What did you find out from Mr. Dornberg?
Well, during my investigation, what I pieced together from what he said was he and Miss Denning had been drinking. They decided to shoot a cannonball off the lifeguard chair. She refilled her drink from the Zeta supply, climbed the lifeguard chair, and went into the pool head first.
Yeah.
Did you find anything else out, Mr. Dornberg?
I did not personally. However, while I was interviewing other the bystanders, one of the other police officers that was there with me told me about some things he heard him say. So I encouraged him to create a supplemental report that he did, and I attached to mine. That we published afterwards.
Permission to approach the witness, we will have Tracy Martin.
Yes.
Without going into the content, do you recognize exhibit?
Yes, I do.
What is exhibit?
We call the reports that were filed, recent following the event, in question today. We filed them after that very same afternoon.
Does exhibit I fairly believe the case for the court in the day filed?
Yes, it does.
Have there been changes or alterations made to it?
No.
Your Honor, we offer exhibit 9 as evidence.
Objection.
Just for part of it, Your Honor, on page 5 out of 5, That was written by Officer Heldrich, not by Officer Bell. So I asked that that be removed for
What's
hearsay,
the basis of that
for hearsay, Your Honor.
response?
We want all of it in or all of it.
So are you agreeing to constructively redact exhibit 9 with the last part of it being taken out?
We would ask that
So what is your response to keep it in? Why does 5, what does that come in?
we, stating the report is hearsay, the report isn't hearsay. The qualifies as inspection because it's a record of the regular.
On the foundation? And
Was it made in the regular course of your duties?
Yes, this is something that typically officer can be respond to an incident, any findings we have, submit a report with, all relevant details. The first 4 pages are mine, this, the last page is, one of my officers that was with me, he made that report, so. Based on his findings.
And was this report made close in time to the incident?
Yes, the, date on there, well, yes, we filed it the afternoon, same day that we reported.
So those are the accurate record of your observations.
Yes, this report matches, what was submitted.
And also are you the custodian of the report?
Yes, this is my report that I filed.
Your Honor, we refer exhibit 9 as evidence of this.
any objection, exhibit 9?
Yes, Your Honor, still to page 5 out of 5 for hearsay.
Still paroled.
Officer Bell, I would like to break it. Page 3 of your report. What did you learn from this firm?
There were a number of things. She was most of the time standing at the door. She had some drinks. The main thing I found out was that she reported that she saw a state Indian climbing the lifeguard chair, falling into.
And I would also like to direct you to page 5. That's interesting. Could you please read the introduction?
Yes. I stood by Mr. Dornberg and attempted to give him some comfort. He was sitting on the sand with his head in his hands, moaning off and on. I heard him say, "We never should have built the lake of the beach. My dad warned me. I should have listened." I asked Mr. Dornberg for 2 weeks said, but he just didn't keep him up. Mr. Dornberg's eyes were very red and watery, and he had a strong odor of alcohol about the person.
Let's talk about your continuing your investigation. Part of your investigation, did you examine Ms. Denny's blood alcohol level?
I did not personally know, but I was provided access to the autopsy in my report, and I actually did include some of the results from there and addendum.
On the fourth page of your report, you can see Ms. Denny's blood alcohol level.
Yes, it was 0.19 milligrams per deciliter, roughly 2.5 times.
Objection, Your Honor, relevance.
Let's talk about Ms. Denny's blood alcohol level.
I mean, your own client, your own co-counsel tried to get in her level of intoxication. So why is it now irrelevant?
Your Honor, I'm just laying the foundation that we both stipulated that she was intoxicated. Going about her blood alcohol levels is irrelevant.
To the world.
Yeah. Yes, Your Honor, may I proceed?
Okay.
All right, how about yourself?
Thank you. So you were on duty the morning of March 25th, correct?
No, it
Early
wasn't
morning.
March, it was in May. But yes,
Excuse me. Yes,
the
May.
night of the incident, yeah.
And you arrived at the scene after the incident had already occurred, correct?
Yes, that was right.
You did not personally witness what happened?
No, that's why I had to conduct the interview so I can gather what the observers had seen.
Right, so you interviewed a Mr. Andrew Dornberg,
Yes, he was one of the 3 primary people.
and he voluntarily spoke with you?
Yes, that's correct.
He was cooperative during your interview?
Well, so he was drunk, so it was a bit hard to get a statement out of him, but yes, he was, and I approached him later that afternoon to give him a chance to clarify if so wish. Yeah, at that time, he was not cooperative, but initially, yes.
So initially, he never tried to run or avoid your questions, just for clarification.
No, I mean, I didn't incident.
He never admitted to forcing Miss Denning to drink, correct?
No, he did not say that he put the cup in her hand, but he talked about how they had been drinking together and that she had refilled it with the day's supply. So he didn't personally hand it to her, but they provided the means by which she was drinking.
So he never personally gave her alcohol, right?
No, but since he said during the interaction that she refilled it, and that they're at the party and it's refilled with this day's alcohol, I assume that he had supplied it and was okay with it.
Okay. And when you were in college, you tried to get into Zeta, as you said, indirect, correct?
Yes, that was one of the frats I left.
But they didn't let you in.
No, unfortunately, I did not get in.
In fact, during the rush process, they humiliated you, isn't that right?
No, that's not.
That's not correct?
No, they did not humiliate me.
That was sworn testimony here?
Yeah, that is.
That they did not humiliate you.
Yes, they did not humiliate me.
Your Honor, may I approach the witness with their please run out or deposition? I am referring to line 14 on page 7.
That's the question, that's not what I said.
Excuse me?
That's what the attorney asked. That's not correct. 114, that's a question, not an answer.
Well, in fact, they humiliated you. Would you answer yes?
No, I said, I don't know what you're talking about. I'm taking some, I don't know what you're talking about. The attorney asked if I was humiliated. I said, no, I don't know what you're talking about. I wasn't humiliated.
So they did make you strip down to your underwear and run across a field naked, correct?
No, I was not naked. I didn't find it humiliating for frat Asian. I thought I got off pretty light. I'm not ashamed to take off my clothes. 3 decades ago, I looked pretty good, so I didn't find it personally humiliating.
Sure, but that was a yes or no. Did they do that to you?
Yeah, that's typical frat Asian.
Okay. And after they made you do that, they rejected you, correct?
Yes, I did not do that. That's right.
And the person that rejected you was Andrew Dornberg's father, right?
I don't know if he was the one who made the decision, but he was the one who conveyed that. Yes.
Okay, and he conveyed it to you in front of a group of your friends.
Yes, he did.
And you still remember that moment, correct?
Yeah, I remember not getting told.
And you said before that Andrew Dornberg's father was a jerk, right?
Yes, I believe that the way he went about delivering it was not very sensitive. Yeah, I don't think he was a very considerate person.
And you even said that Andrew Dornberg was worse, correct?
Yeah, I think he's a jerk like his dad.
And you've investigated Zeta Lambinu before?
Yes, I've responded to multiple incidents there over my time in the police department.
And you've written reports about them in the past, correct?
Yes, that's right.
And you believe that frats such as Zeta Lambinu contribute to alcohol-related issues, correct?
I believe they can. As a member of fraternities, I'm not very proud of it. I just request that they, engage in their parties responsibly.
So you believe that they should be held accountable, Zeta Lambinu, correct?
I believe anybody should be held accountable for their actions.
Now, Mr. Bell, your duty as a police officer is to gather facts, correct?
That is correct, yes.
Not make assumptions.
I report the fact, provide them to the appropriate parties so that they can make sure that the law is followed. That's right.
Of course. But you did not witness this incident firsthand, just for clarification.
No, I was one of the parties responsible for putting together facts that we got from all the witnesses.
And so your findings are based completely on what others told you.
They are based on what I observed and seen, the evidence we collected, the interviews I conducted, the reports we got from the hospital.
So what others told you? That's a yes to my question.
Partially, but I was responsible for conducting a lot of the interviews and looking at the evidence myself. Part of it was
Correct.
from other people. Part of it was also doing my own investigation.
Right, but you were not there during the incident.
No, but I observed the aftermath.
And so it's based on what others told you.
Objection has to be.
Change.
No further questions, Your Honor.
All right, is there any redirect?
Please address, Your Honor.
First off, is there any redirect of this witness?
No, Your Honor.
He stepped down.
He was-
Okay, and he may leave if he wants to go get Super Bowl ready. So, you also rest at this time. All right, y'all wanna take a break before we move into defense case in chief? Somebody say yes. Beautiful. It is 2:30. Can we be back at 5-7 minutes? Beautiful.
Groceries. Don't take groceries.
I said groceries. I didn't say
No, you
groceries.
said
Groceries.
gross.
I said groceries. What is it? Yeah, I do.
Thinking about it, I'm waiting on the public notice and still have another decision as well. Is it? Yeah, if I can, I won't even have an. Yeah. Stay with EAs that was like. We'll just throw you in trial. That's what they say, is like people don't. EAs for trial experience.
Yeah.
Yeah. It's most interesting to me is career. Was it? That's true. Thank you. Thank you.
Is there any water by any chance?
Just a minute. Let me go get that.
No, I'm gonna look it up.
You can't tell for sure. Because there's no one. Wait, you? I can hear you fine,
Yeah,
like
you can.
everyone can hear you.
Yeah.
Like the first thing you learned.
Yesterday when she was opening, so they're all just talks. She's like, presence.
Actress now.
You'd have this was trying.
Nice to meet you, Alexia.
What I've noticed now that I'm not as stressed as everything.
You notice a lot more when you're not right in the middle of it, right?
Mhm.
It's usually how it works.
In the moment, I'm trying to remember what.
Now, customer, I understand, it's super easy for me to sit here and watch.
Sorry,
them do
it wasn't
what
that big of
I'm
an
actually
issue.
gonna fight
Sorry.
my- You won't forget things.
I was calling you.
I totally get it.
Right, I have a quick question. I assume because it's mock trial, a lot of this is just information is evident. On real trials, is that also that basically?
Evidence? Absolutely.
But is establishing foundation.
Oh, yeah, just
Alright.
the good stuff.
I just want cookies.
Much back and forth, or because the lawyers know how to do it by that.
Right, so.
Well, when you start getting better about the rules.
Power to
About what you do.
power to.
Okay.
You know objective things you don't care about, you know objective things that you want.
Okay.
Should be fine.
But yeah, so they're only a foundation for everything.
The beginning, like the
Okay.
history part was like a.
Oh, so don't very much matters.
Drag, the last two cases. It was kind of dull, cause there's like barely words. It's all damn. How is this first? Oh, okay. Oh, okay, cool. Yeah, okay, it was this one. Yeah, slower than it needs to be, but it's better. This is tidy, we're not getting tested. It's right. I'm gonna be buying tidy. I'm trying not to put too much in there. You know, I'm just like my lines. Sorry. That's my reaction to reading it. It gets twisted.
Is that how you organize
The back
it?
of my
I mean, that's
head.
how I did,
Um,
and it also says in
just for
there.
yeah,
It
I
doesn't
seen
say
that.
with.
And
It says
That's my bad.
if you think I'm going 40.
read,
No, all week, keep going crazy.
No,
all
I
week.
saw that. I have mine.
Which does it say as one?
Just
See how long this is?
Yeah.
Probably Tuesday, Wednesday.
Yeah, he
Thursday,
dropped it.
Thursday, that's like. But like. Especially because I don't think. Everything will be possible. Example. Like. the way you-
It said it in here.
Yeah.
Yeah, I
think
know,
it's
I'm
the
so
other one.
stupid.
It's replying, it's like.
And I
keep
can
it
just
as
tell
one.
because he's like.
Wow.
Like international law and politics, and I can just tell
The only
and when
reason
you
I
do
really
that, like he, you know what I'm saying, like he really
He
wants
wants
to know it
check.
in and out. I
Make
know
sure,
he's
like,
gonna
the
be
page
like a
count
tough
counts.
grade. I bet, like what his A paper looks like.
Your Honor, this is ready.
Ready to proceed?
It's done.
Alright. Let's call first witness.
So the defense calls Andrew Dornberg then. Hi, Mr. Dornberg, can you please state your name and spell your last for the judge?
Yes, Alex Dornberg, Oregon,
How old are you?
22,
And where do you currently go to school?
University of Minnesota.
Were you present at the Zeta Organization's party?
Yeah, that was there.
Are you a member of the fraternity? And what is your role at? the fraternity? But at the time of this, your role and what are your duties as treasurer?
Not too much, man. It kind of begins and ends with the opening and closing. Excel spreadsheet.
And were you a part of the planning committee?
No, I wasn't a part of the planning committee. I just went with them this time to make sure they would throw a party.
What do you mean by that?
Didn't want to be a part of something lame. I had my own interest to do something fun for a party, you know.
So how did you know plan the party?
I kind of gave him the theme of this beach party, in beach movie.
And where was the party located?
Yeah,
So how did you meet Kay Denning?
exactly. it was the night of the party, her probably walking by. I remember the name from talking about the family stuff.
Is that when you were on the lifeguard chair?
Initially I was, but I had to find one.
Where did this lifeguard chair come from?
I kind of repurposed the athletics as lifeguard chair.
Was this your idea? Was it the Fred's idea?
No, the friend was going to steal lifeguard chair. This is all no idea.
So were you the one really selling the idea?
Just trying to. I wanted to sell the theme and have a fun part. Why would I want to do something lame and do something else? That would be fun.
And again, was that part of your duties as treasurer, selling this thing?
Didn't know that it was gonna play.
And so when you saw Kay on the lifeguard chair, what happened when they came by?
When they came by, talked to them for a little bit, just some general stuff. I could remember it. And, what was one thing that felt.
And did you see her, Kay, at the actual party?
Yeah, she texted me that she was by the pool.
And what happened after you met up with her?
Talked for a second. Over the pool.
And did Kay have anything with her when you met up with her?
Yeah, it was kind of weird. She had her own cup that's like coffee off or something like that. It was outdoors at the time. I was assuming she brought her own drink or something like that.
But you never, did you directly give her anything to drink?
No.
What happened next?
When the rest came over, most of the party's over. I think it's the
And what happened after that?
It's kind of crazy, man. When I was talking to Courtney, I turned around with the phone. This girl was just chugging, literally was walking the drink, and then looked at me and was ready to dive in the pool.
That's a good scene. Yeah, it's a little late. It's come out already.
And did you tell her anything after that?
One of those really stupid ideas.
So what happened next?
After that, I told him to bring it to the house and then I went up to charge. Next thing I remember, I just like wouldn't scream, and so I went back downstairs. So I put inside like food. So it was exploding
And what did you mean by front of the house?
at the door. On the way back.
And so when Kay was down and the accident occurred, was the party over at that point?
Yeah, the party was supposed to be over at 1. That's why Courtney came over.
And did you ever tell Kay did you ever direct her to dive in the pool?
Absolutely. It was like a pretty cool night.
And were you ever aware prior to the incident that Kay wasn't 21, she was underage to be drinking?
No, I haven't.
And did you ever interact with a cop named Alex Bell?
Yeah, I think that's the cop that interviewed me, but honestly, everything after the event occurred is all just a blur.
Did you notice anything about Alex Bell?
Yeah, I remember he was actually pretty rude to me, during the circumstances. It felt like he had some kind of personal vendetta. against me.
Speculation. Response?
The witness is testifying to the accused, so.
Everybody's guessing as to how what the other person was feeling and their motivations and the objections sustained.
Yeah,
Sure.
so did Alex Bell talk to you the night in question? And did Alex Bell talk to you the day after?
He tried to.
And so when you interacting with Alex, sufficiently the night, providing a question in the morning after?
Sufficiently, I believe.
And what do you do to make you feel a certain way about it?
About my side, so it's all. I think going to the.
Objection, Your Honor, speculation.
So do you feel like a fraternity is at fault in this case, or that you yourself is at fault?
The fraternity,
And were you acting in capacity as treasurer when you set up? Thank you, no further question.
Alright, cross.
Wonder? So let's talk about Mr. Goldberg, how that you were treasurer, usually deal with money matters fraternity.
same budget, that's all.
To make the party, the fraternity. And how are we to acquire, money would be needed to acquire the.
Yes, you have to pay for it.
So you maintain that you weren't part of the party?
No, it's not. I think they're within that night, so maybe put it there just to make sure that it's.
Well, your fraternity got the idea from your dad.
Part of it, my name is from this TV show, the idea that,
And you basically based off of your dad's old parties, right?
he taught me how to.
You were telling me, guys, and. Your fraternity brothers were on the rocks, right? Some of your fraternity brothers were on the rocks in the pool, right? Can you attend that?
Oh, yeah, when I was in the lifeguard chair, they were floating on the rafts and stuff. I water, yeah.
And when you were setting up, you were telling the guys what to do.
I was kind of just screwing around with the megaphone, yeah.
So you were involved in setting up the party, correct?
Everyone was around talking. So that's the party that I was. And telling on the chair with the megaphone.
And let's talk about the party setup. Permission to watch the witness with Hippard exhibit 2. Showing the copy to the opposing counsel. Mr. Goldberg. Without going into the contents, where's the exhibit 2? Is exhibit 2 fairly the people in the setup of the party? So we have
Exactly.
Okay.
Alright, just that.
looking at the exhibit, Mr. Goldberg, the tiki bar wasn't in the back, correct? Wasn't in the backyard, correct?
No, I was just in my house.
The tiki bar wasn't next to the door, correct?
Okay.
Someone could just approach the tiki bar without approaching the door, correct?
That sounds like yeah, I think possibly.
And just to recall, the person checking IDs was at the door, correct?
They're around the door, yes.
Let's talk about the lifeguard. There was a lifeguard chair in the pool, correct?
No,
By the pool? It was facing the pool, correct? There were no safety signs warning people not to dive, correct?
on the chair. because. Anyone should be able to know to dive into.
No one was actively stopping people from climbing the chair, correct?
No, but we had five sandbags. A lot of people facing stupid.
In fact, you had to find the chair yourself.
I had to fix it up for the party.
Does Denny like see you on that chair, correct?
I guess she did for a second or two, after I called it over.
We saw you sit on that same chair, correct?
I almost. I didn't sleep.
Let's talk about you getting this. Were you texting with Denny during the Instagram?
The party was, I guess.
You asked her to explain to you,
I did. I wanted to see that.
you texted her more than once, right?
Yeah, she was cute. I think she should come up.
And permission to the folks to witness. You can mark it too.
Yep, you may.
You're showing the copy.
Yeah, we can make that.
You don't. You have to check that from your phone. Person answering was Miss Denny.
Seems so.
At the front, to offer evidence.
Objection.
Objection to hearsay.
Responses and admission, I heard it to me, either messages from Mr.
May I respond?
No,
Um,
only half of them are actually. Dornberg's messages. What's your response, before you get to it, what's your response to the hearsay or Ms. Jennings' messages?
Council had already previously addressed Miss Denny.
Exhibits have been admitted yet.
You would be fine to keep Miss Denny's messages first.
may I respond?
You may.
I think that because there's hearsay on the document, which they haven't provided exception for. Then it should be excluded.
Well, I mean, we can constructively redact things, right? So I mean, technically speaking, we could constructively redact all Kay Denny's messages, right?
Right, but also in regard to their party, still raised the same responses earlier. This witness just testified that they did at the party in their own accord, not in their capacity. So
Yeah,
therefore,
tell me how these statements are attributable to the fraternity, because Mr. Dornberg is not a party.
We have laid the foundation that he was part of the party, he gave the idea for the party, he invited people to the party, he was part of the organization that threw the party. And the other thing, he is the treasurer, to get things for the party, they need to get money from the treasurer, so he directly is part of the party committee.
Okay, but that's fine. But these statements, how are these statements attributable to the fraternity?
Grammar. And we're gonna go on to we say that the changes are made, the text messages are made by the parties agent, or the fully unrelated to the relationship.
Okay, and that's kind of the point that I'm getting at. I understand that's the law, but I need to hear your argument of why you say that these statements were made in the scope of what he was doing, right? Because, like, for example, I teach at the school. Professor, in addition to being a judge. I'm in the school right now. Statements that I make right now are attributable to the University of Houston, right? So just because I'm here, school, employee of the school, doesn't automatically mean that everything I say or do while I'm here, is scope of my employment with the school. They don't pay me to be here. I wish they did. So, you see what I'm saying? So explain to me why these statements, which seem personal in nature, like he personally wants her there, is pivotal to the fraternity.
He was kind of continually inviting and sending to the party, so he was still acting within the scope of fraternity.
What is the interest of the fraternity in having this Denning there? Sponsor that, Mr. Randolph?
Testify, well, the party was for 21, to keep it 21 and up, and that wasn't K Denning, so they really had no interest in K Denning being there. Established, these text messages can't be attributable to the frat because we've established that many things that the witness did were things that he did in a personal capacity, including inviting an underage girl to the
Objections to stand on that basis. Do you have any other response?
Then let's talk about one thing. Let's talk about the thing. It's remember you said yeah, actually remember before inviting her. Right. So I mean, you didn't know she was only 20 prior to that. Then let's talk about when you saw this thing. Second time after you had first one. When you saw this thing the second time, you met her in the front yard. Right?
Yeah, but
When you saw this in the other front, she had a glass with her. Right?
yeah, something relevant.
And you can tell that she had been drinking.
I mean, I was pretty drunk at that point, so it's not any place to judge anyone's sobriety.
Or better, yes.
Just seemed like pretty happy.
So it's possible that then you may have to couple of alcohol from there.
objection. The question calls for hearsay.
Something
Right, but deposition discovery is different than admissibility. So just because he's previously said it does not mean it automatically admissible in trial. What's your response to the objection of speculation?
Would your honor?
No.
Mr. Darby, you think he may have seen something, not that he needs to.
Maybe approach.
Ma'am,
So. What's the question for us?
Yes. It's that he may have heard of alcohol from Zane.
So. The statement you're trying to bring up, she may have been at the party. Yeah, I would say they're offering that for the truth of the matter asserted. I still think it's
well, it's hearsay, so it's not hearsay. Your objection was speculation, so I don't care if they're offering it to truth of the matter asserted or not. That does not come into play when we're talking about speculation.
I objected to hearsay, but I will add.
Oh, sorry, I heard your objection to be speculation. That's my fault.
Well, I'm objecting to both, so.
Response to hearsay.
Yeah, I didn't think he was saying a statement. So the objection to hearsay is overruled, but what about the speculation?
Mr. Dorn, please say yes.
I mean, even the statement you're saying says that he doesn't know. So the objection is sustained, rephrase your question.
Mr. Dornberg, then you were with Ms. Denny in the backyard afterwards. correct? Past the door where Zeta was checking ID.
Yeah, we go back to the house with us, if I'm doing,
You didn't tell her to stop drinking at any, right?
not a babysitter.
You mean that you and Ms. Denny were going to leave the party?
After Courtney told us the party was over, yeah, it's we didn't talk about it.
And you had left to go change your shirt,
Yeah, I told her to meet me at the front door and I'm upstairs.
so you left her outside.
I told her to meet me at the front door and then she picked up that phone.
So she was outside, correct? When Ms. Denny climbs the lifeguard chair, you were nowhere to be found.
So upstairs,
So that was correct, you were near Ms. Denny? Named that when you came back downstairs outside, she was floating in.
yeah, straining.
Mr. Dorberg, you worked and currently work as a lifeguard, correct?
Objection to relevance.
Huh?
Or Your Honor, we're just establishing your members. Relevance, duty of care, responsibility,
Why does whether or not he ever worked as a lifeguard matter?
because this incident happened. Well. Safety.
Yeah, well, so I understand the testimony, the water level is like knee high.
Yes.
Is that in dispute?
No.
Okay,
What's in this case is Mr. Dorberg, they had referred to them to dive into the nuclear water.
so well, why does it matter if he's a lifeguard or not?
Lifeguards know that you shouldn't be diving into shallow water.
I mean. Why is that not just something, why does he need to be a lifeguard to testify that? I mean, I'm not a lifeguard and I know that we don't dive into shallow water, so why do we care that he's a lifeguard?
He has even more knowledge about situations and.
What relevant information is beyond the scope of a layperson is necessary here? What? Which is sustain.
For the Harvard, then the pool house we have to know about 2 or 3 feet. People know, shouldn't dive into water that shallow.
I want to dive head first, but,
And you certainly shouldn't encourage people to dive into water that shallow, correct? That's it.
Redirect. You're excused. Defense, call your next witness.
The defense would like to call Courtney Perez.
Man,
Good afternoon, Mrs. Perez, how are you? Could you please state your name for the record, spelling the last?
Courtney Perez.
Where do you attend school, Ms. Perez?
University of Miami.
What are you studying?
I am a pre-law major and also.
Oh, what's your business?
I have a side business where I am trying to help with party.
And are you aware what happened on May 26th at Zeta Lampton?
Yes, it was one of the parties that I helped with.
And what were your duties at that party?
Well, my duties are mostly like set up for the party, food. And then I'm the person that is at the door of that party, you know, making sure that no one, under the age of 21 is able to get there.
Did Zeta New have rules for party entry?
Yeah, they're really strict about that. I mean, they really go in on it. They have lots of parties, and they don't want to have problems, so no one under 21 is allowed. And on that day, we made this big, like 5 to 6 foot banner that was hung over the front door that, you know, stated things. And it was my job to make sure that no one got through that door.
Would you recognize, sure of that sign if I showed it to you today?
Sure.
Your Honor, let the record reflect, I'm showing opponents of counsel to propose exhibit 3. Approaching the witness with exhibit 3. What is that in front of you, Ms. Perez?
Oh, yeah, this is the sign. Must be 21 to enter.
Objection, Your Honor, I asked that the exhibit be admitted before she testifies as to the.
She already did, but,
I was just asking if she was recognized. My apologies, Your Honor.
okay, let's, lay a little, let's move for submission, do you lay your foundation for it?
Is that a fair and accurate depiction, Ms. Perez?
Yes.
We now move to enter exhibit 3 into evidence.
Fiction.
Yes, Your Honor.
Well, I think it might be a little untimely because even before we actually talked about the exhibit, she already said what the exhibit said. It's time we should.
Yes, Your Honor. Should have objection to this, so then.
I'm just curious, what is your response?
Well, Your Honor, it falls under 803B6. It is a record of regularly conducted business. We have laid the foundation that.
There are regularly conducted businesses to throw parties?
Oh, no, Your Honor, she owns a business to throw these parties, and in her record, she has created this sign. We were about to lay foundation with Andrew Dornberg. They created this.
Yeah, well, I haven't heard none of that foundation. You've got to lay the foundation before you move for its admission. So if you want to use that exception, you've got to lay all that foundation, put it into evidence before you move for it to be admitted. But I do think that your objection is too late. So court's gonna admit.
Who created this sign, Ms. Perez?
I did it along with Andrew.
Were you stationed at the entrance that night, Ms. Perez?
Yes, I was.
Did you see Ms. Kay Dunning?
Yes, I saw that. I went across this.
What did you do when she arrived?
The same as everyone else. I asked for her ID. She was there with someone else, and so both of them I asked for ID.
Did she provide an ID?
No, she said she didn't have it, that she had left it.
So what did you do?
No ID, no show, so I turned her away.
What happened after that?
She got happy, said, you know, she would get in.
What is the statement?
She's gonna say, I'm gonna get, can I approach constructively?
Yes,
She's going to say, I'm gonna get in one way or another.
I guess we haven't gotten it that, I haven't heard that yet. And I haven't heard anything to where she says that she's going to say that.
That's like he getting said.
She didn't, I'm not saying this.
Yeah, I haven't heard that part yet, but let's just assume, since we're already approached, that that's what she's going to say. Do you anticipate that you are trying to get that testimony out from this witness?
No, Your Honor, I'm mostly trying to establish that Kay Denning approached the door and then she was denied.
Okay,
Yep. May I ask that then she not share that statement?
well, I guess we'll see. But right now, I think your objection is premature.
Ms. Perez, without saying anything about what Kay Denning said, how did she react to you rejecting her?
Yeah, happy.
Thank you, Ms. Perez. And was that the last time you saw Kay Denning?
No, I saw her later when I was doing cleanup. That was because party's supposed to be over at 1 AM, and so I was doing cleanup around that time. I was heading out back and I saw her out back with Andrew.
What were they doing?
I just saw them together and I didn't really think about what they were doing. I just thought about the fact that they were there and the party was over. And it was my job to make sure that everybody was gone. So I told them they had to leave.
What happened next?
I went back into the house to continue doing more cleanup.
Did you see Kay Denny at any point after you went back inside?
Yeah, I saw her later. I was headed out to the front because I was gonna take the sign off the door. And looking through the door, I saw her, she was in the pool, wading through the pool, like towards that lifeguard chair.
What did Miss Denning do?
I yelled at her, get out, you need to get out of the water and leave.
Get a response there.
Excited utterance, Your Honor.
I don't think the foundation has been linked to this account as an excited utterance.
Staying.
What was Kay Denning doing when you saw her again?
She was wading in the water heading towards that lifeguard chair.
What did she do next?
Well, she had a cup in her hand and she was kind of stumbling and I saw her take a drink and then I saw her climbing up the chair and I continued to yell, especially then, that she needed to get down.
Objection. Thank you. Response.
I'm not asking for a statement, can I read it?
Yep, just repeat your question then.
And once Kay was climbing up the chair, what did she do?
I saw her climb up. She got to the top. She kind of wobbled and next thing I knew, she went in head first.
How did she enter the water, Ms. Rose?
It was just, I mean, it's not like she fell on her back or anything. It was head first. Just, and
What did you do after she went head first in the water?
I ran. I mean, I yelled and I ran. I ran over there as fast as I could, you know, before I could get there. And then I started trying to pull her out towards the sand.
Did anyone help you pull her up?
I remember Andrew being there about that time. I don't know where he came from, but at some point he was trying to help me. Yeah.
Ms. Perez, did you see any members of Zeta Lambda Nu allow underage guests inside?
No,
Did you observe any fraternity members allowing alcohol to these underage guests?
no,
Did you encourage Kay Denning to climb the lifeguard chair?
no.
To your knowledge, did anyone else around encourage her up the lifeguard chair?
When I saw her going up there, I didn't see anybody else around her, and I was in the house and she was over in that pool area. No, I didn't see anybody talking to her or saying anything to her.
Thank you, Ms. Perez. No further questions. I pass the witness.
Close.
Yes, sir. Good afternoon, Ms. Perez. My name is Sarah. I have a question. I'll be asking a few questions today. You plan parties, right?
As a side business, I mean, I don't have a storefront or anything like that.
Right, and Zeta has been a client of yours, correct?
Yeah.
And they pay you for your services, right? In fact, at the time of your deposition, you had just thrown one for Zeta, correct?
Yes,
Despite the fact that Zeta is the named defendant in this lawsuit.
yes,
So they're still hosting awesome parties despite the tragedy that happened.
Objection.
Counselor Honor?
Yes.
This is relevant because it goes to show that Zeta's callousness in their character, and it would go to nothing here in setting up the party that they don't even care that accidents like this happen.
You're talking about. You're talking about like their behavior after the fact?
Yes, after, there's still a party in this lawsuit that's still going on, and they're still hosting a lawsuit.
Okay, but why does that matter to whether or not they were negligent on the day? Okay, well, why should you get into character evidence?
So.
Yeah. The objection sustained.
Let's talk about the planning process for that party. Andrew is known for having an abundance of wild and crazy ideas, right?
yeah, I'll say so.
And you thought this party was no exception.
I didn't really feel that way. Yeah. That's what I do is I help them, so they kind of come up with the idea. I'm the person that kind of, goes about picking up supplies and setting up and watching the door, that sort of thing.
Yes. Ms. Price, please stick to my questions. You thought that this party was no exception to his wild and crazy ideas, right?
Yes.
And on top of that, he wanted this to be the best one of the year.
He may have said that, maybe he said something like that, I don't recall.
And the theme of this one was like a beach party from the past, right?
Yes.
Did you know that the Zetas had thrown similar beach parties like this in the 1990s?
Well, I didn't know it then, but, I heard something about it later, I think.
But Andrew had known about these beach parties, right?
Objection, Your Honor, lack of personal knowledge.
Your Honor, if this witness is here, that she's free to say that she did. But Andrew had known about these beach parties, right?
I never talked about anything about like that with him.
So it's your testimony today that you've ever talked about the beach parties in the 1990s with Andrew Dworkin.
Not before the party, not when they asked me to plan what was the party. Afterwards, he said something about it.
Yes, let's talk about what he said about it. Andrew had known about these beach parties, right?
Afterwards, he did tell me something about it.
But Andrew wouldn't say much about it, would he?
No, he said he didn't talk it.
But he didn't bring up any safety concerns during the planning process, did he? But Andrew did not. So you did.
Yes.
Because this party sounded like a bad idea to you, right?
Yeah.
But Andrew convinced you it'd all be okay, right?
Well, he said that everybody was going to be an adult at the party, and so since it was a party for adults, and they were all adults, and so since I'm just there to, set up and.
So that's a yes.
Yeah.
And now one thing you were concerned about was the lifeguard chair, right?
Yes.
You thought it looked old, right?
Yeah.
And rickety.
Yeah.
And you foresaw that people would be climbing, right?
Yeah, it was in the sand and it was rickety, and I thought that since it wasn't steady, if somebody climbed on it, they ought to be liable.
But again, Mr. Dornberg dismissed your worries about the lifeguard chair, correct?
Yes,
And Mr. Dornberg was fine with a bit of danger in order to have such an amazing party, right?
what he was personally fine with, they put some sandbags on the chair and moved it like closer into the water.
So to clarify, you don't know if Mr. Dornberg was fine with a bit of danger in order to have such an amazing.
I think maybe he said something to the effect that if he worried about every little thing, maybe he never had parties or something like that.
So that's a yes. Let's talk about when you were checking IDs. That's when you spoke to Miss Denning, right?
Yes.
And she wanted to come inside because Andrew had invited.
She wanted to come inside, I asked her for ID, she didn't have any ID, so I didn't know them.
But that's not the last time you saw her, right?
No.
The next time you saw her, she was in the back of the bus.
Yes.
So at some point, she comes through the Zeta premises.
I would assume so, I mean, this was after the party was over. When I saw her, the party was already over. That's why I told her she had to leave.
Please answer my questions, Ms. Perez. So to clarify, she was in the backyard, right?
I saw her in the backyard.
So she'd come through the Zeta premises.
I don't know how she came in, but she was in the backyard.
And you didn't tell Mr. Gorman that she hadn't shown her ID to you. did you?
No, I got very busy. I didn't have time to leave my post when I'm supposed to be watching everything at the front door. She's a little thing.
Right, even though you just testified that being over 21 was really important to Mr. Gorman.
Well, it was a rule. Oh, you must be 21.
You thought fun and safety was really important to Mr. Gorman, right?
I think it's a-
But you didn't tell him that Miss Chris hadn't shown her ID, right?
When I saw him with her, I told her that she needed to leave, that they both need to leave before they leave.
Please answer my question, Miss Chris. You didn't tell him that, did you?
I didn't tell him that this person.
That she hadn't shown her ID.
No,
Yes. You know, I later saw him staying again in the front of the house.
I saw her with her.
Yes. So, in the front of the house.
The pool was in front of me.
And you saw her climbing the lifeguard chair?
Yes,
And you yelled at her to get down
yes,
because you knew it was dangerous.
yes, and the party was over.
And she was slipping on it, right?
He was drinking, and yeah, she looked like she was sitting, yes,
And when she got to the top, there was a kind of wobbling around, right?
yes.
And then she came down to her death, right?
And I saw her go down.
And Andrew was there at some point helping to drag her out of the water.
Yeah,
And he was saying, I didn't think she
Actually, we want to hear some.
This is an excited utterance. He's just seen this girl die or come very near to death, or she will die several days later.
They did not just lay the foundation that he just watched her die to say this. They laid the foundation that he came and started pulling her out of the pool.
So what's rather pulling a dead body out of a pool? I would think
You said she's not dead.
pulling a near dead body out of a pool, I think when.
Injections.
Andrew was saying, I didn't think she would really do it. Correct?
yeah, I think I would.
And he said, not again, right?
Yeah.
And then he sat there waiting for the ambulance, just kind of moaning, right?
I guess so. I mean, I was so out of it too, but he was there and those are the things I believe he said.
And then you knew whatever was coming, it's gonna be bad. No further questions, I pass the witness.
All right, you redirect.
No, Radar, John, we just ask that my witness be let us step down.
You may step down. Next witness.
The defense rests.
All right. We do not allow rebuttal witnesses in this jurisdiction. Do you need time to prepare before closing?
The defense asks for
Accept, or do you also ask for 5 minutes? All right, cool. 5 minutes.
The good.
Yeah. Did you take trial on this last year?
No, I didn't. I think for last summer I did transactional.
Any guys what you wanna do?
No, so now I'm kind of getting back into it.
And now you're buyer's remorse.
So I'm like, now I know for sure.
Fair enough.
Yeah.
Well, you tried out. You tried out for the team last year.
Yes, it was actually like really quick after this competition coming up.
It'll be the end of March.
I've been hearing, cause like I'm childhood friends with Olivia, so she told me.
Oh,
all about
Olivia Garcia?
hers. Yeah, she
Aw.
had her best life.
I mean, yeah, she went to Paris, she got a free suit. I mean, I really
Yeah.
don't know.
Went to Disney all the
I know.
nights. Living large.
Yeah, these kids, they're getting treated better than I did when I was in law school. They're getting being treated than I am now. So,
That, yeah. The gift that keeps on giving.
no, all right, we do take 3Ls. Most of our, about, almost 2/3 of our team's graduating. We're gonna have 11 returning members.
Oh, you're saying you can try out as a 3L?
You try as a 2L for your 3L year.
Okay, I didn't know that. I thought it was just 1L. That's good to know. 'Cause we
That's
don't-
why I'm telling you, if it's something you're interested in. We do take 3Ls, Sela, we took us a 3L, Douglas Cooper, we took us a 3L,
I know
and
Sila.
Chris Hall, we took us a 3L. So they joined last year, summer between their 2L and 3L.
I haven't taken a trial ad yet.
You'll have to, Chris Hall taking it right now,
Okay.
but you can try it again.
Okay, that's good to know. It'll be fun.
We like to have a good time.
Yeah.
So you said you didn't like transactional work.
I liked it, just, I don't think that that's like my calling in life. Like it was, like I had a great time, like it was fun.
You
but I'm
mind me
still-
asking where were you at?
Oil and gas title firm.
Oh.
Yeah.
From down to work.
Yes, it was quite different, but I'm still figuring out what I want to be when I grow up, so.
Were you clerking this summer?
I'm working at Keene Miller. It's like a Louisiana-based firm. They
I'm
do
familiar with them. Either have something in my court right now, or
No, it's crazy.
they recently had something in my court.
I'm
I'm
really
familiar with them.
interested in their state litigation. I think that's so cool.
I couldn't tell from the back, but after I saw that, it's like, okay, it was all about the alcohol. Nobody, but it was in the.
Not very often we get those kind of problems in mock trials, that,
It's like,
occasionally arbitration.
All of the
Probably
court
went
that we
arbitration
saw,
like
like,
2 years ago.
You knew like the facts. So
And everyone was
they
kind of
I know
like-
U of H has an arbitration. team. There's
She killed
mock
us.
trial too.
To make a rule.
You were-
You cannot bring arbitration.
I know.
Usually what we do is one arbitration team comes out of the year.
It's like so fun to sit there and
Technically,
like, yeah,
it's
here we go.
Right.
Here it is again.
Another arbitration.
Let's go. That's my mom. That's my mom.
Okay, so it's
So
kind
the
of.
team that just won nationals.
You were a good Andrew too, like.
I don't know, but you could have been the Sounds reason.
Orly, Jacob Parson.
Yeah, good acting, good acting. Yeah, I met Jacob.
Yeah, judge.
Judge for us.
Yeah.
Some more charges.
Maybe
Maybe for like a lot.
I think the team is 27 right now and 16 will graduate.
Wow.
Yeah, we're gonna be losing a chunk of it.
Reorganizing.
So,
Yeah.
see, we never have a set number. Yeah, there, yes. How many we compete, how many we're, yeah.
That makes sense.
And it's
And then
studious.
do you compete, is there a quota? Like, how do you pick or do you assign? How does that?
I assigned who's going to what tournament. If you join the team, you will have a commitment of at least competing. There are inter teams that you've got to do. And then we do a summer inter team and we actually just do our winter inter team. We just did our winter inter team last weekend.
That's for mock trial.
Cool.
Like Orly and Alex Haney won our winter inter team.
Oh, I know Orly.
They're the real deal.
I met her before I came here. She's super nice.
Yeah, so they literally just, we literally just did that. So you gotta do a summer inter team, the winter inter team, and then at least we'll send you out to compete at least in one tournament each semester.
That's cool.
Amazing.
Yeah.
And then they'll be, the coaches, like they'll be throughout, right? Like they'll
Oh, yeah.
be able to coach and before.
Yes, they get coaching for all of it.
Okay, that's good. That's good.
Oh, wow.
Do you choose your partner in there as well, or do they assign a partner?
Well, no, you choose nothing. I sign everything.
Amazing.
Strategy.
I'll assign teams. You and your coaches will decide who,
No.
like who's plaintiff, who's like who's defense, that kind of thing.
No,
In that regard, you'll have some say over, it,
Yeah.
but like I'll assign the team.
What section are you guys in?
Summer to summer. Summer, I'm literally just gonna draw names out of a hat.
Okay.
Summer is
See
the
what
most
happens.
random,
We're
way I
friends
can do it.
before.
I
Yeah.
first pull in all the
Yeah.
returning members
That's
and
how
sign.
we've
them to
always kind of
teams,
talked about
And
it.
I just draw names out for all the new people.
And just go with it.
Yep. See what happens.
That's what we like.
I'll see you there.
I will be
And
there.
the part-timers.
I will. Okay. Experience people closing.
Yes, Your Honor, may I reserve 2 minutes for after the judge?
You, how much time does it do, you said?
You have 7 minutes left.
So you can have whatever time you have remaining, for rebuttal. Just save your time. You gonna ask for any other particular warnings on your time?
Sure. I'm just gonna hold up,
As my co-counsel said at the opening of the case, negligence has a price, and it shouldn't be paid by the victim alone. Zeta was negligent and must pay the price for their actions. We, the plaintiff, must prove the elements of negligence by a preponderance of the evidence. This means that if there's a scale and 2 sides with equal weight, and if other board is placed on our side, we must find the plaintiff. If you think it's more likely than not that Zeta was negligent, we must find the negligent. Let's assume that what opposing counsel said is true. That the party was over, and Ms. Denning was still invited onto the premises by a Zeta member. She refilled her glass with Zeta alcohol, climbed a Zeta party pop left on the ground, and under the direction of a Zeta member, she climbed it and fell. Now, there are only 2 elements in dispute that we must prove to you. The defense readily acknowledges that they had a duty of care to Ms. Denning as she was a guest and an invitee. But there are 2 things we don't agree on. First, we allege that Zeta breached its duty of care that they owed to Ms. Denning. And second, Ms. Denning's death was a result of it. So first, did Zeta breach its duty of care to Ms. Denning? To explain that event, they agreed they had a duty to protect her on their premises as a person exercising reasonable caution. So essentially, did they reasonably protect Ms. Denning? No. First, Zeta admitted Ms. Denning when it knew or should have known that she was underage. We heard Ms. Price testify that she checked her ID, well, she tried to check her ID, and Ms. Denning didn't provide one. And yet Ms. Price testified that she saw her again in the backyard of the house, meaning she'd come in through the front. And we heard from Mr. Bromberg that he escorted her from the front to the back of the property, and Ms. Price didn't let anyone know that she was underage. Second, Zeta admitted Ms. Denning to the party when it knew or should have known that she was intoxicated. The defense counsel readily talked about, the amount that she had been drinking, and we don't deny that. We heard from the and it is obvious that she was drunk and impaired and vulnerable. Mr. Dornberg knew that she had been drinking. Third, through Mr. Dornberg, Ms. Denning was directed to dive off the lifeguard chair when it knew or should have known that she was intoxicated. Mr. Dornberg and Ms. Denning have discussed diving and swimming. Mr. Dornberg testified that he and Ms. Denning talked about swimming and diving. Then he says he told her they needed to leave and not swim, that he was super responsible. But we learned from Ms. Bloom that Mr. Dornberg was coming to hop off the street. He said, "Don't go diving without me." Those don't sound like the words of someone who wants to leave the party. It sounds like the words of someone who has encouraged the other person to take a dive. The second element we must prove is that Zeta's negligence was the actual and proximate cause of the decedent's death. And I tell you those words because the jury charge is going to ask you them. And to explain it, actual cause means that Ms. Denning would not have died but for Zeta letting her in when she was underage. She would not have climbed up and jumped off or fallen off the lifeguard chair. But for Zeta letting her in when she was intoxicated, she wouldn't have done that. But for Zeta through the actions of Mr. Dormer, encouraging her to dive into this standing wouldn't happen. An approximate cause means that a reasonable person would have foreseen that there were possible dangers and would have taken reasonable steps to mitigate them. And we saw that today. Now, Ms. Price testified that he did foresee dangers, and yet Mr. Barber dismissed them. She helped plan the Zeta party, and yet this dangers were dismissed. She knew that chair was rickety and old, and that someone might climb it, and she expressed those fears. We knew that Mr. Dornberg knew that an identical party had been thrown before with someone getting seriously injured. We heard that from Officer Bell. Mr. Dornberg should foresee the danger of someone diving into such a shallow pool. Mr. Dornberg, a reasonable person, would know that. Even a lifeguard, especially a lifeguard, and he would know better than to tell someone. He should know to stop someone from jumping into the pool, and he should especially not encourage. Let I just walk through what it says. If you think that Zeta's actions were unreasonable, and the Stenning's death was a result of those actions, you must feel it.
Minutes? How much time is it left?
He has 15.
Somehow. It's not a requirement to utilize all of the time.
All 15. Eight choices. The weight of Kate Denning's choices. Now, unfortunately, we're here today to defend an organization called Zeta Lab. The girl died too young from life birth. I'm not arguing that the incident wasn't tragic, it wasn't horrific. But unfortunately, it's Kay's own choices that caused her death. Now you're here to decide whether Zeta Lambda is that. You do that by the preponderance of the evidence. What does that mean? Imagine a scale. On one side, the evidence that the defense brought is. On the other side, evidence that we brought, defense, in this case. And those will be weighed against each other. Whichever weighs more, even by a hair, you must decide for them. And so, before you decide, I want to walk you through this question just one more time. Kay and Chris were getting prepared for a night out. But this wasn't just a normal night out, not for Kay. Kay recently unenrolled in all classes. She was suspended from her sorority. She was worried about what her mother might think, worried about her being in the sorority. And that's the mindset she was in when she went out. So what happened? They started off the night at a Mexican restaurant. From there, they headed to Zeta Landing. They walked by Zeta. And Kay saw hanging. Her life. She saw with her own eyes, and she almost slipped. She met Andrew. And they kicked it off. It was a flirtatious vibe, as the kids call it. And Andrew got a liking to Kay and Kay back at him. And then they left. And they tried to get into this party. She liked Andrew. She had a crush on Andrew. She really wanted to be in that party. So badly that she was arguing with Courtney Perez, doing her job at the door, keeping people like Kay, like Chris, from getting in. They knew they shouldn't have been there. They were under 21. Kay, furthermore, was suspended from her sorority. She wasn't in good standing. Furthermore, not supposed to be there. She knew all of this. They weren't successful, so they went off to a different party. Kay was drinking. testified that she was wasted, smoked marijuana, ate a weed route. And she headed back to the farm. That she was determined. No matter if what she's gonna get in there. Any means necessary. So after the party had ended, Kay got in because she was gonna get in. By any means necessary. She had a crush. She was gonna see it. So the party was over. Kay was in the party. She knew she wasn't supposed to be at. And Andrew met up with her. And they were gonna leave. And Evan told her to wait by the front door. She disregarded that. And she went to the floor. No frat member or no organization member could stop her. They weren't there. She did that by her own volition. It was her own choice. Unfortunately, she made the choice to dive off. She died. Her choice. Now, the plaintiff presented an argument today trying to establish the organization as negligent. But their testimony, frankly, is all about Andrew. Andrew, who was the treasurer at the time, whose official responsibilities started and ended Microsoft Excel. He came on the stand and he talked about how his official responsibilities were the budget. Everything else was someone else's responsibility. But he wanted to make sure he had a good time. So he butted in and did things that he wasn't supposed to do under his responsibilities. Such as this life coach, which demonstrates how any fault was owned by Andrew shouldn't be attributable to the threat, to the organization. This lifeguard chair belonged to the Zeta organization. It wasn't bought into the Zeta organization funds. And we just went and got it from the athletic center. The plaintiff failed to establish that if Andrew had any fault, that it should be attributed to the fraternity. In fact, the testimony today, everybody who was acting in their official capacity were doing what they were supposed to do. Courtney came to the stand. She talked about how she was making signs, and she stood by her post and did her duty all throughout the night. She denied Kay and Chris because they weren't supposed to be. She didn't leave her post to tell Andrew anything because her post was the front door, and that's what she did. For life. So when you weigh the evidence today, it's clear that the organization should not be involved. Now, the jury charge lists two questions. One, is the front liable? Now,
Yeah.
Hopefully that's not broken. So, two questions. Is the organization liable? And if they're not, well, the organization isn't liable. But if they are, we have a second question. Who bears majority of the fault? Zeta Lambda or KD? And today the defense has made it abundantly clear that if anyone bears the responsibility in this case, it's KD. Now maybe Andrew will get 10 to 20%. He definitely wasn't acting in his official capacity as treasurer of the fraternity. So Zeta Lambda bears 0%.
Does she have rebuttal time?
You have a minute 44 seconds.
We just heard counsel testify that we've been focusing on injury, that we haven't been addressing Zeta. And yet I seem to remember consistently bringing up Zeta and talking about Zeta letting her in. She was unhappy. That if Zeta letting her in, she was unhappy. She filled her glass with Zeta alcohol. That was in her list. She found the Zeta pot. And yet, direction of the Zeta member led her to Miss Courtney Perez, an agent of the fraternity, as she was within her capacity of creating the party, saw concerns, and yet she left the chair. She said, "It's dangerous. It's rickety and old." Miss Denning would be here today, if not for Zeta's actions. Miss Denning left behind her family, his friends, and a future that could have been hers. Now Zeta, who caused this terrible pain, is refusing to acknowledge the part that they played in it. Justice demands that they pay the price. Don't let the victim pay it alone.
So much. Yeah. Big Brown. Tell me y'all's first names.
I'm gonna cut off the recording now.
Shara? Shara.
Maddie.
I am student lead and the director of the mock trial program. I'm also a sitting judge here doing some work. Very familiar with this problem because you know why? I wrote the charge to it. This charge was a modified NTC problem. So when I looked at it, I was like, did they use the original version or did they use it when I updated it by like 3 years? Use the updated version, which makes sense. Otherwise, finding a case that an event that happened in 2013. Now, way, way a long time ago.